Attorney Newland, it's my understanding that you are here on behalf of the appellant. Did you wish to reserve any time for rebuttal?
Yes, sir. 4 minutes, please.
Okay, I will do my best to find a good time to let you know when you're about to convey that time.
I appreciate it.
Okay. With that, we are prepared to begin. Counsel, the floor is yours.
Thank you, Your Honor. Thank you. Good morning. My name is Nicole Dees Newland, and I am here on behalf of Anthony Fantozzi, the appellate in this case. This case concerned a final judgment in an underlying action that was entered against Mr. Fantozzi. We believe that final judgment is void, and therefore the trial court incorrectly denied Mr. Fantozzi's Rule 1.540 motion seeking relief from that judgment. The trial court based its judgment on two effective arguments. One, that Mr. Fantozzi had quote unquote notice of the proceedings, and two, that Rule 1.540 was not a proper mechanism by which Mr. Fantozzi could seek relief. I'm going to take those in order, absent any questions from the court directing otherwise. So the notice of the proceedings, obviously due process requires both notice and the opportunity to be heard. Case law is replete with examples of where that fundamental statement is set forth. Obviously, the notice requirements vary depending on the circumstances of a particular case. In this case, Mr. Fantozzi was not a party to the underlying proceedings. He was an attorney for a party. And therefore, when he was receiving notice of an ongoing proceeding, he was receiving it in his capacity as attorney. There are some critical dates, and I'm sure the court is aware of the facts, but when this court entered an order granting a fee motion, and that happened in November of 2022, this court's order stated appellee's motion for appellate attorney's fees is granted. The appellee's motion for attorney's fees was filed prior to Mr. Fantozzi's appearance in the appellate court action. In fact, it was filed approximately 23 days before Mr. Fantozzi ever appeared in the appellate court action. Mr. Fantozzi appeared in the appellate court action and was never subsequently served with a 57-105 motion, was never thereafter named in a 57-105 motion, never received a 21-day safe harbor letter as to the 57-105 motion, and there was never an amended motion filed after his appearance. So when the trial court stated that Mr. Fantozzi had notice of the proceedings, they are referencing, presumably, or it is referencing 4 notices of hearing that were filed by Mr. Fleck. And those are detailed extensively in the brief, but for all intents and purposes, those notices of hearing were filed on November 9th, November 17th, December 12th, and again on January 3rd. In those notices of hearing, Mr. Fleck identifies what is effectively being heard is this court's order granting the fee motion. It does not otherwise state that he is seeking fees against Mr. Fantozzi. It does not provide. Yes,
am I recalling correctly, there was no additional motion for fees filed in the trial court after the appellate court ruling?
Correct. Mr. Fleck filed the order by this court and then requested a hearing on it with the trial court to determine entitlement or amount, because this court had previously determined entitlement.
And the motion for fees filed in the prior case in this court specified that it was seeking fees as a sanction against appellant Mr. Day.
It did, Your Honor.
And after that motion was filed, Mr. Fantozzi appears in the case and nothing else happened in the appellate court regarding a claim for fees against Mr. Fantozzi.
That's accurate.
And nothing was done in the trial court notifying Mr. Fantozzi that the appellee was seeking fees to be split between Mr. Day and him.
That is correct.
Okay.
You have summarized my sum and substance of my argument, Judge Silverman. The notices of hearing did not place Mr. Fantozzi on notice that his personal rights were at issue. They identified that the court would be hearing this court's motion or order granting the fee motion that had been previously granted, but there was nothing identifying Mr. Fantozzi or notifying Mr. Fantozzi that his personal rights were implicated.
Ms. Newland, let me ask you this. I believe the motions did recite the statute 57-105 subsection 1, which does dictate that the court hold, them equally responsible for the attorney's fees. And so one of my questions, is, a final judgment is entered. And yes, there's the notice that the attorney, he had that the hearings were happening. But then the final judgment is entered and he's copied, your client's copied on the final judgment and does nothing for a substantial period of time until the 1.540 motion is filed. So why should, the time to appeal that judgment would have lapsed 30 days. So why should he be allowed to challenge this on a 1.540 when he certainly had notice of the final judgment earlier because he was copied?
Yes, Your Honor. Just for point of clarification, the motion did not reference subsection 1. It asked for sanctions 57105 attorney's fees as a sanction against appellant Mr. Day. This court, when it granted appellee's motion for attorney's fees. It did not specify a subsection. Just so
Thank you.
Yes,
Okay.
ma'am. Under Aran, this court's decision from 2012, it held that the trial court erred in finding an attorney and a party jointly and severally responsible when the attorney was not identified in the motion for fees as an individual against whom fees were sought. Understanding that Mr. Fantozzi did not check his email as to the final judgment until March, which would have been past the 30 days for filing an appeal or a 1.350 motion for relief from judgment. There's honestly, Your Honor, Mr. Fantozzi's testimony was that once he had withdrawn and been relieved from further responsibility in the matter, which happened in January. It happened he had filed, he set his motion to withdraw on December 15th for a hearing on December 28th. On January 3rd, the court entered the order granting the motion to withdraw. And at that point, that order thereafter stated that Mr. Fantozzi was relieved from further responsibilities. He did not check the email. There's no testimony that came from anyone other than Mr. Fantozzi at the 1.540 hearing that he didn't check it. Honestly, Your Honor, there's no obligation to check it once you're relieved of the responsibilities to check an email or an e-service email. Whether it's best practice to or not, that is not the issue. The fact remains that the testimony was that he did not check it. And in Sterling, which was another decision that was decided, and it's kind of bearing on the issues here. In Sterling, which was a second DCA case from 2007, this court looked at the question of whether or not he had actual knowledge. Mr. Fantozzi's testimony, and the only testimony, was that he didn't have actual knowledge. And in Sterling, we didn't go back, or this court didn't go back and look at why they didn't have, or why they had knowledge versus, or why someone didn't have knowledge, which is what the question is right now. And again, the only testimony is that Mr. Fantozzi did not have knowledge.
Okay, we didn't have actual knowledge. Would this be constructive knowledge? I mean, this is his e-service email, right? Where he day to day would look at the email. So at best, he would have had constructive knowledge.
That's not the case law. And the case law seems to suggest it's actual knowledge.
Actual knowledge, okay.
And so I guess my concern would be, there are oftentimes that attorneys are included on certificates of service for cases once they have withdrawn. And it creates an obligation for attorneys to continue to check those emails, even if they have been relieved of further responsibility in the matter. For whatever reason, whether the client fired the attorney, whether the attorney had in this case, Mr. Fantozzi had the permission by order of court to withdraw and be relieved of further responsibilities. And that should include continuing to check those emails, absent some notification to Mr. Fantozzi that his rights were at issue, right? So in this case, if Mr. Fleck said, I am seeking fees against Mr. Fantozzi, he had the obligation to seek it in the motion. If in a worse circumstance, he came back and said, well, now I want them, he never told Mr. Fantozzi that. There was evidence of emails exchanged between Mr. Fleck and Mr. Fantozzi, where Mr. Fantozzi indicated he was withdrawing. Mr. Fleck never said, hey, wait a minute, I'm going to seek fees against you. You really need to be here. Or, hey, I'm going to file this motion seeking fees against you. Or here's a copy of the final judgment that is against you. there would be no reason for Mr. Fantozzi to believe that when that final judgment was sent to him, that it would include a judgment against him. Perlman is the case, Your Honor. It's Perlman v. Atlas Holding. It's a 4th DCA case that came out after all of this happened. It's from September of 2023. And it said that the trial court violated the non-party's rights, which would be Mr. Fantozzi, because he was not a party participant. He did not appear as a party, was not represented in the proceedings, and had no notice that the trial court was considering entering an order adjudicating his rights. And the case law, again, is clear. Notice after the fact is not sufficient notice. A motion for rehearing is not sufficient to provide the party with due process in advance of or at that time of the hearing. And I hope I've answered your question, Judge Smith, in a very long-winded way. I don't believe that Mr. Fantozzi had an ethical obligation. He was relieved from responsibility by virtue of the court order. By the time that he became aware of the final judgment, it was too late to pursue relief under those other options, which is what was addressed in Sterling, right? Was the fact that the individual had actual knowledge in time to move for rehearing or appeal, and Mr. Fantozzi did not. We have discussed some of that. Again, I know that the court is well aware of the cases and the bases that we are seeking reversal of the trial court's order on the 1.540. So I think it's probably, absent additional questions, I can probably hold off and just come back at the end and do my rebuttal, even if it's a little longer then, so that the arguments may be better framed, unless the court has further questions now.
There appears to be no further questions. Mr. Fleck, you may proceed.
Thank you so much, Your Honor. This is Attorney John Fleck of Bradenton, Florida, appearing. Judge, can you all hear me?
Yes.
Thank you. Judge, the first thing everyone has to consider is the standard of review. The standard of review is abuse of discretion. So in reviewing the lower court's ruling, you have to find that the court abused its discretion in denying the 1.540 motion. That's a high burden to find an abuse of discretion. Next, the lower court is the trier of the fact, and that's an important issue. What opposing counsel said as to her view of the evidence, respectfully, that is not relevant nor material to this case. Judge Sniffen made specific findings of fact. Those are the findings of fact. And Your Honors would have to find that there was no basis in fact for Judge Sniffen to have made those findings of fact. He indicated, Judge Sniffen, that Mr. Fantozzi had actual knowledge of all the proceedings, which meant those proceedings leading up to the hearing on the amount of attorney's fees. What's important to look at is in the other appellate case, the order of attorney's fees came out on November the 4th of 2022. Mr. Fantozzi was the attorney of record at that time. He did not withdraw until December the 9th. That's 35 days later. Mr. Fantozzi, if he was confused about the court's appellate order awarding attorney's fees under 57105, he then had sufficient time to file a motion for rehearing or a motion for clarification in that appellate case. He did not do that. Next, once he withdrew, he still was the attorney of record in the lower court case. All four of those notices of hearing, which are contained in the record, clearly indicate that they were served on Mr. Fantozzi. And then you saw, even after
Mr. Fleck, I don't think there's any dispute that Mr. Fantozzi got copies of the notices of hearing. Was there anything filed by you on behalf of your client indicating that fees were being sought against Mr. Fantozzi?
Respectfully, the last two notices of hearing went to Mr. Fantozzi even after he withdrew. If you look at the last two notices of hearing, they went to him after he withdrew to put him on notice of the hearing. If he had any confusion, it was his responsibility.
Mr. Fleck, my question is very specific. Did you provide any notice to Mr. Fantauzi that your client was seeking a division of fees against Mr. Day and Mr. Fantauzi personally? I
No,
think the
and we
answer is
did,
no.
and that respectfully, Judge, that's a red herring question because the appellate court had already entered the order of fees and the remand to the lower court was only on the amount. There was no legal reason for us to have filed a motion against Mr. Fantuzzi in the lower court because one, the lower court has no discretion as to whether to award fees or not. That's
Did
so.
you file a motion in the appellate court after Mr. Fantauzi appeared in the case that you were seeking attorney's fees, or you were going to file a motion for fees under 57-105?
As to Mr. Fantauzi, there was no need to do that. That motion for attorney's fees was already filed and pending, and that appellate panel.
So any attorney who comes into the case after the fact is potentially on the hook for a 57-105 sanction on a motion that was filed a year before the attorney appeared, or 3 months before the attorney appeared.
If you saw what Judge Sniffen said, Judge Sniffen, which says, if you come into court, into a case, you have an obligation to review the docket. So when Mr. Fantuzzi comes into that case, he has an obligation to review the docket. He sees the pending 57-105. And under case law, you as an appellate attorney or as a lower court attorney may not continue to proceed with a frivolous case. Your obligation at that point in time is to tell your client, we have to dismiss the case or you have to withdraw. Mr. Fantuzzi made a conscientious decision to continue with that case, to continue with oral argument, and we had oral argument up in the appellate court in person. So Mr. Fantuzzi made those decisions to continue to pursue that. Moreover, again, if he thought that he could not be on the hook for attorney's fees because there is no provision, then his responsibility was, when the appellate court came out with the decision, was to raise those issues in the appellate court by a motion for rehearing or reconsideration. Moreover, even if everything was done wrong, Mr. Fantuzzi was served with the final judgment for the amount. And if you notice, the record showed that not only was he served through the e-portal, but the judge's judicial assistant personally sent the final judgment to him by email. So we're talking about an attorney who had actual knowledge, and he had actual knowledge of the final judgment because he was served by both email and by electronic service. In some of the cases where you talk about 10, 12 years ago, where you had to put them on actual notice, receipt by an attorney or by a party or by anybody nowadays of email and by judicial service, those are actual knowledge. We're no longer in the days of where you have to send a certified letter or by mail.
He's no longer attorney of record. He was granted leave to withdraw. So does he have an ongoing obligation to review everything that is sent to him after the fact?
Especially if it's from a judicial assistant, yes. And if it's through the e-portal service, yes. Because if he didn't want to receive it, then he would have deselected himself from the e-portal and he would have been notified the judicial assistant. He could have solved any ambiguities by deselecting himself from the e-portal and by responding to the judicial assistant, I'm not a member, I don't want to receive this. He did none of those things. And to suggest that an attorney can ignore emails, ignore judicial service and say, well, I didn't have actual knowledge. Whether you want to call it actual knowledge or constructive knowledge, you're under an obligation to read your emails that are coming from a judicial assistant. And if you see a final judgment, then you have some obligation to read that final judgment and to know what it says. And you take that at your own risk. And moreover, again, you would have to find that Judge Sniffen abused his discretion in making these findings of fact and making these conclusions of law. Mr. Fantuzzi tried to wait until all his legal remedies had passed, and then he says, oh, I didn't read my emails for 2 months. Well, if he wasn't going to read the emails, then why did he read them 2 months later? None of that makes legal sense. Judge, respectfully, there is no legal basis for Mr. Fantuzzi's 1.5040 motion Judge Sniffen did not abuse his discretion. And when Judge Sniffen said, I think once the final judgment was entered, there was some obligation to take action. If we allow litigants, non-parties, or anybody else to say, oh, I can just sit back and wait instead of following the normal procedure. And if you notice, when the Supreme Court talked about this, they said, so long as you received the final judgment and you had it, then you had some obligation to file a motion for rehearing, file an appeal. Mr. Fantuzzi did not take any of the avenues available to him. And also, he did this to the prejudice of his own client, attempting to shift the burden of the entire amount of attorney's fees to his own client. Quite a conflict of interest when you look at his conflict of interest and his responsibilities to do that. Even if you withdraw from a client's case, you still have some obligation if emails are still coming to you to either deselect yourself from the portal, notify the judicial assistant that you're not involved in the case. That would have resolved any of that. He was clearly negligent in protecting his own interests, if you believe his testimony. Judge Sniffen saw the testimony. He decided what he chose to believe, what he not chose to believe, and there is no abuse of discretion. Thank you.
Hey. Attorney Newton, you have your 4 minutes remaining.
Thank you, Your Honor. There was no testimony there was no questions asked of Mr. Fantozzi why he did not review it until March. Mr. Fleck had the opportunity to ask those questions. He did not. Mr. Fantozzi's unrebutted testimony was that he did not access it until that point. If the final judgment is void, and that's a de novo review, if the final judgment is void for lack of due process, then the issue is whether or not Mr. Fantozzi had notice and the opportunity to be heard before the judgment was rendered. And the answer to that question is he did not. And so if that final judgment is void, Judge Sniffen abused his discretion. He acted unreasonably in determining that Mr. Fantozzi had notice of the proceedings when the notice that was provided never provided Mr. Fantozzi with notice that his rights were at issue. And when Mr. Fantozzi had no actual knowledge that that judgment had been entered against him. Again, whether or not Sterling is binding or not, that's this court's opinion in 2007. And in Sterling, the defendant had been served with the appropriate process, participated in the proceedings, and admitted that it had received a copy of the final judgment within a few days of its entry. This court specifically said the party chose not to use an appeal or Rule 1.530. Mr. Fantozzi didn't have a choice. He didn't know that a final judgment had been entered. That's the testimony. It's unrefuted. There was no evidence that Mr. Fleck had sought fees against Mr. Fantozzi, provided notice to Mr. Fantozzi in advance, or otherwise told Mr. Fantozzi that his rights were implicated. For those reasons, we do think the trial court abuses discretion. We think the final judgment's void, and that this court should reverse Judge Sniffen's order and find that the final judgment is in fact void.
Thank you, counsel. That will conclude this oral argument. And we allow you to electronically transfer back to your point of origin and invite you, if you wish to hear the last case on the docket. But we will understand if your life is a little busier than that. So thank you very much, and we'll let you exit. And we'll call our last case Bartolotta for termination.